All right, we're gonna get started here. Give us like one more minute, minute and a half. People are still joining. I hope that everyone is ready to talk about disclosures today. All righty, but a few more seconds here, let a few more people join. We had 185 registered, but typically not everyone shows. All right, everybody, it's 8 o'clock. Let's get rocking. Today we're talking about NABOR disclosures. Can everybody see my screen? I see Deborah's giving me the thumbs up. She's the referee. All right, so we're talking about NABOR disclosures and what you're required to disclose under the NABOR contract. So I'm very excited to talk about this today because I get a lot of questions on disclosures. So we're going to go through, there are a lot of them in the NABOR contract, but we're going to go through them, make sure you understand them all. Of course, because I am an attorney, we start off with a disclaimer. For those of you that have been on my webinars before, you know that I am giving you advice, but it is not legal advice, and we're not creating an attorney-client relationship, but you can always reach out to me anytime. I've been practicing for over 20 years. I practice in real estate and business law, and I have a full service law firm that handles probate, estate planning, association law, litigation, and we do have offices throughout Southwest Florida for those of you that like to come in and meet in person, but we handle things throughout the state. A little bit, I've got a title company that we do real estate closings for. So for your closing services, if I can help you in any way, hablamos español, and we are really, what I would say, very good at protecting your customer security. We spend a lot of time focusing on data, and if you have any questions about that, you can reach out to me at any time. So we are going to dive right into the NABOR contract in terms of all the disclosures that are required to get you under contract with the NABOR forms. I am going to provide a webinar on the FAR disclosures, which are similar but different in many respects. We're going to go through the NABOR contract, walk through all the disclosure items, starting with the CDD, and get all the way through the section standard D disclosures. So that's kind of the plan for the day. Starting off with your community development districts, what is a CDD? Oop. It is a governmental unit created to serve the long-term specific needs of a community. It's created under statute, chapter 190, and it is a quasi-governmental entity that borrows money and issues bonds and then pays off the bonds by charging fees to the homeowners within the district. So it's for infrastructure and amenities. And it provides like a broad range of quality of life issues like stormwater management, sewer and wastewater management, street lights, irrigation. It can provide things like street maintenance, things like that. And it provides a more reliable source of funding, and it comes up with in developments where the developers are needing to offset their costs for things like the clubhouse and the pool. Um, So they get those things in early, and then they issue these bonds to pay for them, and then you pay them back when you buy your house. What does the form look like? This is the form that attaches to the contract. So in your NABOR contract, you're going to check the box for the CDD in section 5, I believe. And section 5 will say that there's a CDD, and then you provide this disclosure. On this disclosure, you will see that you put the seller's name, the property address, the name of the CDD, which I'll show you where to get that on your tax bill. You put the outstanding balance of the capital assessment. You put the installment payments for the capital assessment. You put the installment payments for the operating and maintenance. And then here on the form is the total of the two capital and operating costs. So the question is, where does this money come from? Or where does this information come from? I mean, it's two places. You need to go to the website and of the district manager, which that information is provided in the NABOR forms. You can pull out a list of all the CDD managers in Lee and Collier County, and you can call them and you can get the numbers that you need to fill out this form, or you can look on their website. I will tell you though, the website's very hard to figure out. Usually the website's very hard. The other thing is the municipal services taxing or benefit unit. This is also disclosed as a part of the NABOR process, NABOR contract process. It does not have the same management that the CDDs have. You have to call the county to get this information. But the one thing is, where can you get this total number right here that's going to be filled on this blank or on this blank over here? I'll show you where to do that. It's on the tax bill. And this is the number that matters. I'm going to zoom in so you can see. Right here under non-ad valorem assessments, and I can't zoom in anymore, unfortunately, you can see you have amounts circled in red. Those are the numbers that show your totals for the CDD. If you can read it, it says the Gateway Services CDD, and the total amount is $2,593.19. So that $2,593.19 goes where the places that I've circled here on the form. Right here. Here or here if you're dealing with a CDD or an MSTU. Does anybody have any questions about CDDs? Peter? No. Okay. So the next disclosure we're talking about is the old homeowner association disclosure. You are probably familiar with this form if you've sold it in HOA, if you've received it from from a seller. So I'll show you the form in a second, but one question I always get asked is, what are some of the thoughts? What if there's more than one HOA? Well, you would need an HOA disclosure for each HOA that covers the property. So you may have a master and a property owner association. You notice in here, I put on here condo association. I noticed that a few minutes ago. This does not require an HOA disclosure summary. You do not use a condominium, an HOA disclosure with a condominium. You would put on there one-time fees such as capital contributions. They do not go on the HOA disclosure. There's a worksheet for that, and I'm going to show you that as well. But I do want to draw your attention to one thing here, this Temple versus Southern Homes case. This is a bad court case. This court case says that if you mess up the HOA disclosure by 1 penny, your buyer has a right to terminate all the way to closing. So when we fill out the form on your screen, I really want you to be careful to make sure that you do it correctly. So let's go through it. You put the name of the homeowner association at the top. You put the amount of the regular assessment in the first blank here under paragraph 3. You put the frequency with which it is paid in the second blank. If there are any special assessments, you put them here in the third blank. If you can see my hand on the screen. And you put the frequency of any special assessments, if it's one time or quarterly or twice a year, or whatever it is, here in the fourth blank in number 3. In number 6, you put any land use, rent, or recreational amenities fees that are paid and the frequency which they are paid. You don't put condo fees on here. You don't put capital improvement fees on here. You do not put transfer fees on here. I see this happen a lot, and what it does is it creates the opportunity for the buyer to terminate at any time up to closing because the proper disclosures have not been given. So the question I get all the time is, Sam, how do we disclose all of the other fees? And NABOR provides a worksheet. I'm going to zoom in on this. You can see it a little better. But you can see here that you put the amount of any fee, the frequency with which it is paid, who it is payable to, such as if it's, for example, in Naples, Pelican Bay Foundation, $10,000 per one time payable to Pelican Bay Foundation. 4, it's the capital contribution or the transfer fee or the improvement fee, whatever they want to call it. And you list them out here in this list. Now, the nice thing about this form, because I know a lot of brokers don't like this form, they're very concerned about liability if it's incorrect. It contains in 2 places very large disclosures that say here and here, it is the buyer's responsibility to verify their fees. So be very careful about that and make sure that you understand what the disclosure is. The buyer is responsible under the contract and this form to know their fees. So your HOA disclosure, be very careful in filling this out so it's not incorrect. And use this fee form for all the other fees. Does anybody have any questions about the HOA disclosure or the CDDs?
I do, Sam.
Sure, Christy.
If a seller provides the information for the association and they put it in the wrong spots, or they give us a HOA disclosure and they have one-time fees on it or whatever, as discussed, you just said is incorrect, how do
Sure.
we address that?
I would send a very nicely worded email to the listing agent, tell them that you've investigated the community and you found different information and ask them to correct their disclosure and have it signed appropriately because you don't want it to be incorrect. You notice here that the seller signs this HOA disclosure summary, and you don't want it to be incorrect because the buyer can get out at any time prior to closing. Other
Okay, so
questions about these forms? Okay, let's talk about the flood disclosure. So there's a new flood disclosure across all of Florida, whether you're using FARBAR or NABOR forms. Each form set has its own style, but that is the same questions on all the forms. They're statutorily created questions, which means the legislature passed them, they're in statute, and we just cut and paste them into our disclosure. As of October 1st, 2025, every single residential transaction, 1 to 4 family, vacant land for residential purposes, do you hear me that? Vacant land for residential purposes, single family condominium, you must have a flood disclosure. You are checking the box whether there's knowledge of any flood damage, filed any insurance claims, received FEMA assistance, and then they define flooding. And the NABOR form does ask for the buyer and the seller to sign. Here's what it looks like. Let me zoom in on it so you can see it better. And you can see the seller has knowledge or no knowledge of any flooding that has damaged the property. the seller has or has not filed a claim with an insurance provider related to flood damage, including NFIP, that's FEMA flood damage, or the seller has received or has not received assistance for flood damage from FEMA. And now the definition of flooding is very interesting because it says a general or temporary condition of partial or complete inundation of the property caused by any of the following: overflow of inland or tidal waters, that's your typical hurricane flooding, unusual or rapid accumulation of runoff or surface waters from any established water source, such as river, stream, or drainage ditch, that's more flooding quickly, and then sustained periods of standing water resulting from rainfall. So let me ask you, if your condominium floods because it's on the second floor and the third floor above flooded, do you need to say that you had flood damage on this property? Anyone want to take a shot at that?
Yes.
Yes.
No, Monica.
Oh,
Notice the
I got a
definition of
50-50.
flood, where it comes from. It's from rainfall. So if you had water filling up in your unit and it was unusual or rapid, it has to be from a river, stream, or drainage ditch, not the upstairs pipe. An overflow of inland or tidal waters, which is not the upstairs pipe, or sustained periods of standing water resulting from rainfall. Now, be very, very careful, because if you have a insurance claim on the property, the NABOR contract says that the seller does not know of any insurance claims in a separate disclosure that we're going to go over soon. So be very careful. Just because I want you to fill out this form properly and understand the purpose of this form is because it's related to the state and FEMA. This does not absolve your seller from having to disclose other insurance claims or flood issues depending on their situation. So let's talk about one more thing about these three disclosures we've just gone over: the CDD, the HOA, and the flood, and then we're going to get into the NABOR standard D1.
Sam, real
Never.
quick.
Oh, go ahead, Christy.
Why the flood disclosure for vacant land?
That is a question for our esteemed legislators. I do not know. I believe it is because if it's residential and it flooded, a buyer might want to know that so they can properly build a new home on it, maybe raise it up. But I can't say I know what was in the legislature's mind when they included vacant land in that. Yes.
Gotcha.
Other
It's
questions?
because it's because. It's
Go ahead,
because they
Christy.
said so.
Because they said so. That's right. Yes. Other
Sam,
questions on these forms? Michael.
is there any limit to how far away the rain event has to be? Like it's raining in Ocala, the river comes south and floods down here, but we didn't have any rain. Does that affect any of it?
If it floods here, sustained periods of water resulting from rainfall, rapid accumulation from a river, stream, or ditch, or overflow of inland or tidal waters, if it's any of those things, which it sounds like it would be B or C, you would need to disclose if your property flooded.
Okay, great. Thank you.
Yep. Sue, that's a great question. Sue in the chat is asking if the fifth floor unit does not flood, but the garage flooded, doesn't need to be disclosed. And there's been a lot of debate at the NABOR legal resources on this question. If the condominium building, the common elements are flooded or damaged from hurricanes or other flooding events, I would think that you would need to disclose that on this form as has flooding of knowledge that has damaged the property. And the reason for that is, in a condominium, you own your share of the common elements and limited common elements. So it is part of your property. It's on your deed. So I would say if you have a fifth floor condo, but the common elements flooded during the hurricane, you need to disclose that. Yes. Other questions on these forms? Okay. Let's talk about one last thing. on the NABOR contract, at the bottom of the contract, just like the FAR contract now, you have a series of checkboxes for adding additional addenda and riders to the contract. However, you should not, please don't add the disclosures to the contract by checking the box and clicking other and then writing it in, because they are disclosures. They're not binding parts of the contract, and we don't want them to be in a lot of cases. For example, we don't want contract law with regard to representations and warranties to apply to the CDD. It's not a mandatory disclosure. So things like that. LOEs are asking, how long is the sustained period for vacant land and does it pertain to the entire property? Any sustained flooding LOEs, and yes, it pertains to the entire property. Yes. Okay, let's get into the NABOR disclosures. There's a lot of them. We're going to go kind of quickly, but we're going to go through all of the mandatory seller's disclosures and advisements in the NABOR contract so you have a brief understanding of what they are. So there are 5 seller's disclosures: the general, the wetland, the permanent violations, the zoning, the past insurance claims. Zooming in on each of them. The general disclosure you should be very, 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 very familiar with. Why should you be familiar with this disclosure? Because it applies to you as a realtor as well. Hear me out. As a realtor under Johnson v. Davis, there are court cases that say you as the realtor have a separate legal duty to disclose to a buyer any latent defect that materially affects the value of the property and which are not readily observable to the buyer. What does all that mean in plain language? If the seller tells you a secret about the property, that there's a damage that the buyer is not going to find, you cannot keep the secret. You must tell the buyer. If you don't tell the buyer and the buyer finds out later about the damage, which they always do, I get 2 or 3 Johnson v. Davis calls a week from buyers, you will be sued separate from your seller and your broker will have its own liability. So be very careful about disclosing latent defects, hidden defects that the seller knows about. Wetlands. Seller does not know of any portion of the property determined to be wetlands or of other conditions that would affect the property for residential use. So you can't use the NABOR contract for commercial transactions, and you have to disclose if the property has sustained water on it in the form of wetlands. This also says that the property is only used for residential, so be very careful again about using this for commercial transactions. Don't do it. Permit violations. Seller does not know of any improvements to the property which were made without proper permits or any open or pending code violations. Open permits are not title defects, they're inspection items under the NABOR contract. But remember, there's a representation that the seller does not know of any. This is a contractual representation. So if the seller does know of open permits or code violations, then the seller is immediately in breach of contract when they sign the contract, and the buyer can get after them for damages. So you need to have a conversation with your seller. Did you make any unpermitted improvements? And beat it out of them. Zoning. The seller has not commenced any proceedings to change the current zoning classification of the property, and they're not going to initiate any proceedings. They've got no notice that there's any zoning changes. If they do get a zoning change, this gives the buyer an out because the seller has to notify the buyer, and the buyer has 5 days to terminate. So note there's an out here if there is a zoning change. I've actually never seen this happen, but it is in your contract. Okay, we talked about the next one, past insurance claims. Seller is unaware of any past insurance claims on the property which would increase the cost or restrict the availability of coverage for the property. Notice how broad this language is. Unaware of any past insurance claims would increase the cost of insurance coverage. Any insurance claim is going to increase the cost, even a small one. So your seller needs to notify the buyer in writing prior to contracting of past insurance claims. So talking again about our second floor, our third floor condo that flooded from the unit above, if you made an insurance claim to your property casualty insurance company, and not FEMA, you would still need to disclose this to the buyer. Any questions on these seller disclosures?
When they say that the seller is unaware, if they are aware, then where do they disclose that?
I would actually, that's a great question. I would actually write that into the contract in other terms and conditions. And I would just say, seller is aware of a past insurance claim for X, and describe the insurance claim. Maybe if you've got, if it was your seller, maybe give a copy of the claim information along with it. Deborah, these are embedded in the contract. These are not separate disclosures. This is standard D of the NABOR contract. Other questions on this?
Yeah, does that seller awareness, does that extend beyond when they owned it? For instance, if they
Yes.
bought it on a previous
Yes.
one?
If you know that your seller's seller had a flood problem and it's affecting insurance on the property, you need to disclose it. Yes. Okay, mandatory disclosures. There are 5 mandatory disclosures required under Florida law. You're probably familiar with all of these, but we'll just touch on them briefly. Radon, lead-based paint, mold, property taxes, and flood disclosure. And the flood disclosure, I'll show you, just admonishes you to look at the flood disclosure we went over. But the radon gas, radon is a naturally occurring element. It builds up when you keep the doors and windows closed. So open the doors and windows, air your property out. Radon is an inspection item. So if you do have high radon, the buyer can request the seller remediate that. And the limit is 4 picoaries under the EPA guidelines. So let's, I see some comments coming in. I will address these in a moment. So lead-based paint is just a notice. If your property was built prior to 1978, that is December 31st, 1977 or older, then you need to add the lead-based paint addendum. And be very careful with the lead-based paint addendum because you as the realtor sign it as the agent, not the broker. So make sure it's correct. Don't forget the addendum. Mold, in Florida, mold is commonly found indoors and outdoors. Interior infestation by certain mold can cause property damage and health problems for some persons. This is the mold disclosure, and basically mold is an inspection item as well. It's an air quality test. You're looking for more mold inside the house than outside the house. Property taxes, make sure that you explain the property taxes to your buyer are paid in arrears. So they're going to be getting a credit on the closing statement for the property taxes if they buy between January and October, and they will give a credit in November and December when we have the actual tax bill. But they may be obligated to pay taxes in the year, and the ownership may trigger a reassessment. I can say that it will trigger a reassessment and taxes will go up. Your buyer needs to understand that. Flood disclosure, we talked about the flood disclosure, but in the main contract itself, it says the buyer should not read and should not execute this contract till buyers received and read the required flood insurance disclosure. So there are 9 advisements and acknowledgments in the contract that put the buyer on notice for a variety of things. Some of these are very, very important. Number 1, insurance availability. The buyer in the NABOR contract is responsible to investigate insurance prior to signing the contract. That means that if you are taking buyers out, you should be talking to their insurance agent and giving the insurance agent information about the properties that they're looking at so they can get an understanding of their insurance costs up front. And if they're financing the property, they will be buying insurance. single family and for most condos, actually. A square footage advisement that this is to protect you. The buyer needs to independently verify the square footage prior to signing the contract. The next disclosure, very, very important disclosure. A lot of fights over this disclosure. The property is or may be located in a community with a mandatory or bundled golf club membership. The buyer may be required to pay certain fees. If the buyer has questions, they should contact the club. This is an advisement to buyers that puts it on the buyer to understand the community in which they're buying. That means you, the realtor, need to understand the community in which your buyer is buying. So you need to fill out that worksheet and understand all the fees. Like, for example, if you're up in the Vanderbilt Golf Club up there off of Vanderbilt and I think Livingston or somewhere over there, you're going to see a lot of fees. There's about 8 of them. And you want to make sure that you have properly disclosed to the buyer that they need to investigate the club. Similarly, they need to investigate the community. Buyers advise the association may not include certain information about noise levels, foreclosures, insurance, budgets, golf course assessments, financial information, and other amenities and things. The seller does not have to give you all that information in an HOA, for example. They only have to give the HOA disclosure worksheet that we talked about. So the seller nominates the buyer to figure out what's going on in the association, and the buyer can inquire, and hopefully the association will cooperate. That doesn't often happen. Energy efficiency. Does everybody know that on every residential contract, you need to provide the energy efficiency brochure that's also in the contract? It's found in Form Simplicity if you don't have that brochure, but on every one of your transactions, you should talk about energy efficiency. For people that sell on the beach, the fire sprinkler safety system retrofit. If your buildings are more than 75 feet in height and they don't have the old sprinkler system in it, then you need to disclose and the buyer should check and talk to the fire marshal. Code compliance. As many of you know, if you've been around Collier County since 2014, Collier County set up a code compliance program and created a brochure with NABOR back in, I think it was 2014. And so there was a code compliance residential program brochure that you need to give to your buyer as a part of the contract. Fair housing, you need to give the fair housing brochure. It's an equal opportunity in housing provided by NAR, and the Federal Fair Housing Act requires that you give out this brochure. So make sure you're doing that. The last thing I'll talk about before we open up to general questions is the FEMA rule. And hopefully you all are aware of the 50% FEMA rule. If your property is below the floodplain, that is below flood, below the first floor elevation is below the floodplain as determined by FEMA on the FIRM maps, that's the flood insurance rate map, then you have a property that's going to have some problems getting improvements. What the problem is, you cannot spend more than 50% of the value of the structure. So on improvements to the home at any one time. So what does that mean? If the house is $1 million and the lot is worth $900,000, and I'm talking about my old house that I sold back in 2022, 23, 22, I sold it in 22. It was a $950,000 lot and a $50,000 house, which means my buyer could only make $25,000 of improvements to the house because the structure was only valued at $50,000. So think about that from the buyer who wants to go in and remodel a home. If it's below flood, they really are going to have a hard time doing that because Collier County, the city of Naples, Marco Island, Lee County, Fort Myers, all have restrictions on how often you can make improvements if you're below flood to meet this 50% rule, and they're all different. So be very careful about that in terms of making improvements to property below the floodplain. All right. Questions. Let me go through some of the chats and then we'll open it up to everybody. Deborah asked, are these disclosures embedded in the contract? Yes, they are standard D. Can a flooding and insurance claims be disclosed in the seller's property disclosure? Lori is asking. Yes, they can and should, Lori, but that does not absolve your seller from producing the flood disclosure and acknowledging any insurance claims in the seller's disclosure. So be very careful that you get all that information to the buyer prior to contracting. Adam B. Adams, you're discussing polypiping. Now, polypiping is not a defective item under the NABOR or FARBAR contracts. It's a frustrating item, but it's not defective if it's not leaking. So be very careful about poly. I would disclose poly because it can create an insurance issue, but it's not required. David is asking what FEMA rating is below the flood zone. So, David, the FEMA flood rating looks at the level of the land across the whole country and says some of it will be flooded every 100 years, some will be flooded every like 25 years, some will be flooded every 500 years. I think what we're used to is the 100-year floodplain, where you see on the flood disclosures like the AE8, like my house is AE 8.3. That means that I am 8 feet above sea level, or I'm supposed to be 11. So like my house is below the floodplain. AH and yes, Kim, it does include AH and AE. Deborah says the Ave Maria CDD is now at a 4th category of reserves. Oh, okay. Yes, if Ave Maria is a new category, then we may need to amend our form, Deborah. I'll check with NABOR on that. Teresa, can you add the mold, radon, and drywall disclosure to other in the contract? Teresa, do not do that. They're separate disclosures. Do not add them to the contract. You don't need to do that. Robert says, if a condo has a separate master, what documents are disclosed to both associations? Robert, that's a great question, and it's not an easy one. If I'm in a condominium and that condominium has a master association wrapped around it, like is multiple condos in one association, like there are like some of those big developments on the beach, or Gray Oaks, or Pelican Bay, not Pelican Bay, Pelican Marsh, then if the condominium disclosure information, the frequently asked questions contain the information for the HOA amounts, the HOA fees, like they're all paid in one bill to the condo who then disperses to the master, you do not need an HOA disclosure. However, in almost every case, I would recommend that you fill out a separate HOA disclosure and condominium right addendum to contract for each association, whether it's 1, 2, 3, whatever it is, associations. Why do I recommend that? Then there's never a question. Did you give the proper disclosure? So in terms of a best practice, if you have a condominium in an HOA, while it is not absolutely required if the condominium dues contain the HOA dues, I would always separate and fill out an HOA disclosure for each HOA and a condominium addendum for the condominiums. And if you have questions about the condominium addendums, I have a separate YouTube video talking about condominium addendums, and I will be happy to direct you to that if you email me separately. Other questions?
Yes, I have. If I took my notes correctly, the 3 additional brochures out of all these advisements, all of them are in the contract. However, the separate brochures are that we need to attach is the energy efficiency brochure, the
Yes.
code compliance, and the fair
Yes.
housing.
That's correct.
Okay, and then the second question is the code compliance brochure. It seems to me, if I'm recollecting correctly, that it is for unincorporated
Unincorporated Collier
Collier
County.
County.
That's exactly right,
So,
Christine.
I looked up the unincorporated, so I know what they are.
Yeah, you have 3 cities in Collier County. You have Everglades City, Marco Island, and the city of Naples. So if you're selling in one of those three municipal boundaries, you don't need the code compliance brochure, but anywhere else in Collier County, you do need code compliance. David is
Everglades City,
asking
Naples, and what?
City of Naples, City of Marco, and City of Everglades City.
Marco, okay.
David is asking, what are PACE loans and are they common or relevant? David, PACE loans are now forbidden. However, there are many hundreds that exist currently on properties. PACE stands for Property Assessed Clean Energy. This is for solar panels and other energy improvements to homes. There were a lot of unscrupulous providers that provided these loans. If you come across a PACE loan, it will be on the tax bill. They're old enough now, they should all be on the tax bills. However, if it's one of the last ones created in the last 18 months, it may not be immediately on the tax bill. So you need to ask your seller, have you taken out energy efficiency loans to improve your property? If you see solar panels, absolutely ask about PACE. But they're not called PACE anymore. They're called something else now, but I believe they're still not allowed in Collier and Lee County, or Collier County and the city of Naples, I mean. Other questions we have? Okay. Thank you all very much for your time today. Oh, we have one more.
Sorry, I was trying to hit my unmute. You stated that PACE loans are illegal now?
They're no
Is that what
longer
you said?
allowed in Collier County and the city of Naples. The statute is still on the books, but they're no longer authorized. They're not, I wouldn't call them illegal.
Okay, sorry. I misheard, but I guess I'm just a little curious as to why? Because of the scrupulous, is that?
There are a lot of bad actors were making PACE loans and screwing old people.
Absolutely agreed there. Okay,
Yeah.
thank you.
All right, everybody. Thank you very much. I
have a
appreciate your
question.
time today. If you have any additional questions, please email or text me. I am available anytime. Talk to you soon.
Yeah, I have one